Good evening, everybody. It's just me. It's Brian Burke. It is Monday. It is 6 o'clock p.m. and my name is Brian Burke once again. I am an immigration attorney with the law firm of Shihab, Burke. You can see their logo floating, our logo floating somewhere up above my head. It's Monday, it's 6 o'clock, and that means it's time for us to bring to you an immigration issue that we think is important and interesting and timely, and that's just what I'm going to do. The topic of today is a topic we've touched upon recently. It is birthright citizenship in the United States. And we have an important update on the subject, which I'm going to share with everyone here. So before I get to where we are, which is new injunction, I'm going to talk a little bit about where we've been and how we've gotten here. So way back when, what seems like a long time ago, really about 6 months, first day of the Donald Trump administration, January 20th, he put out an executive order that says, hey, birthright citizenship, being born in the United States, isn't really a thing anymore. Why? Because under their new interpretation of the rules, it's that basically if you're, let me see here. It's basically attacking people who aren't children of U.S. citizens already. Basically being people here on non-immigrant visas, people who are unlawfully. And it really kind of shook us. Shaking the foundations of what we know about U.S. citizenship law, that if you're born inside the borders of this country, you become a U.S. citizen. Great. So again, under this injunction, only people with a U.S. citizen or LPR parent would become U.S. citizens if the child's born in the United States. So as what happens in U.S. law, people sued. People sued. They took the case to federal court saying, hey, the government's overreaching on this. Their new interpretation of this is wrong, off. And a bunch of judges agreed. A while back, there were injunctions, nationwide injunctions, court orders that said, for the benefit of everybody in the United States, government, you can't do this. And there were a bunch of injunctions that prevented the federal government, the executive branch, the president, from doing what he wanted, reinterpreting the rules of birthright citizenship. Great. Fantastic. Then the case went to the Supreme Court. And Sam and I talked about this maybe when the case went to the Supreme Court and also when the decision came down a few weeks ago. And the case that went to the Supreme Court previously was not one that was really about birthright citizenship. Basically, the administration, the executive branch, the Donald Trump administration, they challenged not whether they were right on birthright citizenship, but whether these courts all around the country could basically stop them from doing what they wanted. They said, whoa, 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 whoa. There's nothing in the law that allows these puny little federal courts to stop us, the executive branch, from doing what we want to do, from doing our job, from using our constitutional powers to enforce the law. We think the law means this. We think the Constitution, the 14th Amendment, says that people aren't just a U.S. citizen because they're born in the United States. That's our interpretation, and these federal courts cannot stop us. And the Supreme Court agreed, and they basically said, and this is where it gets fun, this is where it gets a little bit lawyerly. The Supreme Court said, you know what? For the last while, we've been seeing too many of these nationwide injunctions from random courts all around the country. And we don't think that lower court should be able to do this. We don't think that just because somebody sues in, Pennsylvania or Wisconsin or, New Hampshire, that the reach of that court should go across the United States just based upon the type of cases that we're filing. So what the Supreme Court said is, you know what? The proper way to get a nationwide court order that stops the federal government, that stops the executive branch, that stops the president from changing the rules on birthright citizenship is to get something called a class action certified. Basically, class actions are sort of a special type of lawsuit where you convince a court that there's a whole bunch of people with the same sort of issue, and that if you put them all together, their rights can be protected. Class actions are sort of common in like products liability scenario. Let's say there's like a car that's hurting a lot of people, and owners of that car could be a class. Let's say typically products liability is the sort of thing, so that's a good example. But so immediately after the Supreme Court issued this decision that says, nah, these nationwide injunctions aren't right, but what you could do is a class action, which are totally allowed under the law, is that the American Civil ACLU, American Civil Liberties Union, basically went to court in New Hampshire and filed a case as a class action that basically asked the court to make us a class and protect us, the class, protect all the people who are going to be subject to this new birthright order from it. And that's what's happened. I'm going to put up on the screen a copy of, what this new court order says, because I think it's really interesting, and I'm the sort of guy who likes to put the legal documents in front of people. And I'm going to push this button, and hopefully it's going to come up, and hopefully you guys can still hear me. Let's see if it comes up. Hey, there it is. So here it is. This is the order granting their motion for class certification and appointment of counsel. And here it is. So this paragraph up here explains, yep. You showed us that, there's a bunch of people who are so numerous that you can't all actively sue. It would be crazy for them to all sue. They have common issues, common questions of fact and law. Basically, they're all subject to that same birthright citizenship, and they're all either have born or going to be born and be subject to this order. They have very similar claims, basically meaning that there isn't a need for a bunch of different lawsuits because everybody has the same issue. And then ultimately is the people suing in court going to protect this group. But here's what they said. The court said, yep, you've got your class action, and here's what we're going to do for you. Class of people, the entire nation of people, here's what they're going to do. And I'm going to read it for you. You guys can read it, but I'm going to read it because it's fun to do for me as a lawyer. In light of the above, this court grants the petitioner's motion and provisionally certifies the following class for the purpose of preliminary injunctive relief. All current and future persons who are born after February 20th, 2025, where one, that person's mother was unlawfully present in the United States and that person's father was not a U.S. citizen or lawful permanent resident, or two, the person's mother presence in the United States was lawful but temporary, like on a non-immigrant visa, like an H1, H4, L, and the person's father was not a United States citizen or lawful permanent residence at the time of state birth. So basically, this court order that prevents the executive order that would have gone into effect originally on February 2025 is basically not enforceable for the time being against people who would be subject to it, being those who were unlawfully, basically the children of people unlawfully present, or for people who are children of people who are on temporary visas and present in the United States. So this court order kicks down the road the question of when does that birthright citizenship issue take effect, the potential new policy from the president administration. Great. Well, so this is a temporary order, and the nature of this, the reason why a judge would grant a temporary order like this is because they believe that the case that's brought, forward, the concept of, whoa, the president can't change the way this rule is interpreted. The judge has to believe that they're likely to win on their arguments. And I think this judge really does believe that, because if the judge called the executive order lawless, unconstitutional, and cruel. And cruel, there's nothing against the law being cruel, but against being lawless and unconstitutional. That's one judge there who's really convinced that, this case is winnable by the people that are suing the government, and that's why they certified this class and issued this order in the first place. Now, a couple things to know. One, this order comes with a 7-day stay in putting into effect that would allow the Department of Justice to appeal. And boy golly, they are going to appeal. And this thing is going back to the Supreme Court. We knew this thing was going back to the Supreme Court without a question, because the bottom line is the last time we talked about this being at the Supreme Court, they did not talk about basically what does the law, the Constitution on birthright citizenship say? What does it mean? The Supreme Court did not touch that. They just said, answer the question as to whether or not the government can, whether the courts can stop the government from changing the interpretation. Now we're going to get back to whether or not the president can do it. That's what's going to be on its way back to the Supreme Court. We don't know exactly how fast, but realistically, it would seem likely to come back in October. That's if the Supreme Court abides by its normal terms, basically by the normal schedule. But it is definitely possible for the Supreme Court to pick this up sooner, and that's really kind of it. So, short answer, for the time being, right now, a court in Massachusetts, New Hampshire, same region, and court in New Hampshire has said class action certified. We're giving these people an injunction that prevents this order from going into effect. How long? We're still within the appeal window. This is going to be appealed to a higher court and eventually the U.S. Supreme Court. And we're going to be back here talking with you guys about it. So things are really still sort of up in the air because a lot of people are calling me right now, calling Sam, calling Joe, calling everybody in the office saying, hey, I'm going to have a child born. Will my child be a U.S. citizen? And the answer is, unless you are already a lawful permanent resident or U.S. citizen, this thing is still sort of up in the air for you and everybody else. So it's worth talking because I don't think we got the opportunity to talk in this venue here on YouTube about what happens. What happens if this does go into effect? And, the thing that's been worrying me about this is what kind of rules do they have to put into effect? And there have to be rules because I am thinking about that child that's going to be born here in the United States, this, shiny new baby. And what do you do with them if they're not a U.S. citizen? And there are sort of, some thoughts, is that do you just give that child immigration status? Do you give that child the status of their parent? Is that easy? Can they do that? But can they give that child immigration status in the United States? That child who's going to be theoretically born here is going to be not a citizen of the United States. I guess they're going to be a citizen of another country, but it's really that's really a question because another common thing that we're getting a call about and people being worried about, it's children becoming stateless, being children without a nation. And it's a real potential problem because what if, the country where the child was, where their parents are from, if that country doesn't give that child citizenship and the U.S. doesn't give them citizenship, it creates a real problem. It creates, it's a child without a nation, a government responsible for them. And no matter whether you believe that those children should be granted U.S. citizenship, for example, you kind of have to worry about those children because basically people who don't have a home, they can be subject to abuse and, other problems, but, abuse. And that isn't good for anybody. So I have talked a fair amount about, birthright citizenship and about maybe what to expect if a change goes into effect. I mean, one theory is that they'll just basically say, fine, you're born to somebody on H-1B status, you're on H-4. You're born to somebody on L-1 status, you're on L-2. I don't think that necessarily works very well. I think there's going to have to be some sort of registration system for those, children that are born here in the United States and hypothetically don't become U.S. citizens at birth. I foresee, having to do some sort of immigration filing. A longer-term implication is, who is a U.S. citizen? A big, easy part of my job is that I don't deal as an immigration attorney with the average U.S. citizen who's by birth very much because you don't have to worry about immigration. My birth certificate evidences that I'm a U.S. citizen. Great. I don't need a passport. I don't need a certificate of citizenship. If we find ourselves in a world where you have to go through extra hoops to prove your parentage, to prove that you're a U.S. citizen, it's the sort of thing where you or where you, me, and everybody else who was a U.S. citizen by birth probably needs to go out and get a passport or get a citizenship certificate because if it's not approved by the government, how will everybody know that they're a citizen? For me right now, I'm about 40 years old. I'm born in 1985. My birth certificate is good, but I'm a realistic person and I'm still going to look 40. I'm going to start looking older. But in the future, when somebody wants to figure out if you don't do it when that child's born, I guess is what I'm saying, is that records go away. because there are all sorts of cases that we do in our office where somebody is trying to prove that they're a U.S. citizen through parentage after the fact, and there are people out there who are U.S. citizens right now who can't prove it because they don't have the evidence anymore, because the evidence is old. I guess what worries me is that there could be a real glut of need to document U.S. citizenship from birth and do it right by giving records to the parents. And if people forget to do it, people go, nah, it doesn't matter for me because I don't think it's going to impact my child. It could potentially do it. That child could find themselves, at an adult age, if something happens to their parents, in a spot where, shoot, I don't have the people who would have been able to help me document the fact that I am a U.S. citizen. My parents, for example, are gone. And that's something, I think about myself right now. My mother's still alive, but my father passed away 15 years ago. If we were living in a world where, where birthright citizenship wasn't a guarantee, had to prove your parents were U.S. citizens, with one of those parents gone, I'm sort of kneecapped in my ability to prove, that. So there's a lot to think about for the future, but big prediction is that this thing's going back to the Supreme Court, and we're going to get, there's going to be updates on this probably before the end of the week. Conveniently, I'll be back here on Wednesday to talk about them. But forgetting about that, let's talk about the questions that you guys have live. Get your questions in because I'm going to try to answer them. I'm also going to be answering our questions from immigrationquestions.us. For those who aren't aware, I'm going to push the button and see if my partner's name, Sam, comes up here too. Hey, there it is. Immigrationquestions.us is a fun little website that we run where you can, during the week, go ahead and submit your immigration-related questions to us. And if we don't get to them live during this show right here, well, we're going to come back to you and make sure you get an email so you get an answer. But we have a couple questions in here on immigrationquestions.us, and I'm going to try to answer them here. And I'm going to get to the ones that are live, so get them in. Don't worry about that. So the question we have here is, my wife from India has been on green card since 1996. I'm a naturalized citizen, and my 2 kids are citizens by birth. My wife has never been outside the United States for more than 5 months. She is in school, district job with the USA for the last 17 years. Will she be questioned on staying on green card for 29 years without becoming a citizen on her entry into the USA? Thank you for your help. So, that's a good question. I'm going to look up your name here as to I know how to address you here. From RJ. RJ, that's a great question. So basically, the short condensed version of it is the U.S. government going to be concerned that I've been a permanent resident for darn near 30 years and I haven't become a U.S. citizen? There's no reason to believe that you're going to have a problem. But for me, as an immigration attorney, I am programmed to ask the question, why isn't that person a U.S. citizen? But there's no requirement that people be a United States citizen. There are probably personal reasons for not wanting to do it because there is, tax liabilities associated with being a United States citizen, for example. Or perhaps you have a citizenship of another country that you'd be forced to give up if you became a U.S. citizen and you want to maintain that. That's fine. But anytime somebody asks me, Brian, am I going to have a problem with travel? The very sort of first baseline answer I have to give them is, the only people guaranteed to entry to the United States are U.S. citizens with their passport in hand. And without that, you could potentially have problems. I didn't see anything in that fact pattern from RJ that says, any reason why his spouse should have a problem. No criminal history, doing nothing that could upset the president's administration's sensitive political policies upon, talking about, wars in the Middle East, for example. I don't think there's any reason why anybody who's a permanent resident should have a problem traveling right now. But again, my baseline answer is that the only people guaranteed that entry to the United States are U.S. citizens. And, that's sort of that. Gonna hit up the questions that we have live here and keep on coming in for me because they are fun to answer. From Ratchet, I'm employed on the H-1B visa and my spouse is working under the C-26 H-4 EAD. If we both travel on advanced parole, can I continue to work on H-1B visa and can my spouse continue her employment with H-4 EAD? That's a really good question, and you've really sort of zeroed in on the issue. So there is an ancient policy memorandum that says essentially this. If you leave the United States while on H-1B status, you re-enter using advanced parole, and what this policy imagines is that if you don't have an employment authorization pursuant to your green card, pending green card case, that we're going to honor your H-1B work authorization. That policy predates the existence of the H-4 EAD. To the best of my recollection, the H-4 EAD was put into effect in 2015 sometime, and that's that. I don't think it's not clear that H-4 work authorization can continue, and that's what I have to say to that. What I would generally tell you is my recommendation and preference for any client of mine who wants to travel with a pending green card is to absolutely try to travel and get an H-1B and H-4 visa. When you enter the United States using your advanced parole, you enter in as a parolee. The only thing that keeps you lawfully present in the United States is the fact that you have a pending green card. And that green card application is not guaranteed to be here, forever. And ask me how I know. It's because I talk to people about it. Sometimes you get struck. You get hit with a problem when, yep, I left my H-1B status behind. I now have a pending green card, and that's all well and good until they deny the I-485 application. That I-485 application pending alone does not give you the protection of being on a non-immigrant visa. The way I usually put it to people is that non-immigrant status, that H-1B status, has been very good for you for a long time. Keep on at it, maintain it, and keep it until a green card is in your hand, because that's the best advice that a guy like me can give you. Maintain your non-immigrant status until a green card is in your hand. So there's somebody with a good name, Weekend RV Getaway. I'm the sort of guy who has a vague interest in buying an RV, but I don't think I would ever commit to one because they're huge. But I digress. Hi, Brian. EB3 progressed by 1 month. I am 15 days short for final action date, but filing date is already current. My guess is that filing date is used only for family-based visa. Is that correct? So, let's see here. Gets his filing. No, that's not correct. So basically, every month they put out the visa bulletin. The Department of State puts out the visa bulletin, right? And the visa bulletin has 2 sets of charts. One of them is the final action dates. That means, can we put a green card in your hand? And if your final action date is current, you can always file I-485 or apply for a visa at the consulate based upon that. But there's the dates for filing. Dates for filing is sometimes USCIS will allow you to file based upon dates for filing. And the way you figure it out is you go to the visa bulletin website, and every month, shortly after the visa bulletin is updated, USCIS issues their own sort of decision. And they say, hey, on this website, here is what we're going to go by. So I'm going to look up that right now while we're here live. And it's uscis.gov/visa bulletin info. And it's such a good website. I'm going to put it down here in the chat for everybody to follow along with me. And click links on the internet at your own discretion, but I'm trustworthy, I swear. And that will take you to the USCIS page where they say, hey, here's what charts we're going to take. And I mean, again, it might be that they're only taking the final action dates, but let's see what they're saying. For August 2025, for employment, they are taking the final action dates for employment-based adjustment status applications. So maybe the way I interpreted your question was essentially that it's not it changes every month is the bottom line. And on this month, August 2025, for employment-based cases, they're accepting final action dates, and for family cases, they are accepting dates for filing. If you want to ask that inevitable question of, gee, when do we think they might accept those dates for filing an I-485 application? Typically, that will come in October. No guarantees, but usually at the beginning of the fiscal year, they will accept dates for filing for the first month or two. Obviously, what we're dealing right now with is a new administration. And that new administration might have different policies on how they treat the visa bulletin. Maybe they won't want more people getting the benefit of those dates for filing, but it remains to be seen. So there is that. It's worth talking, since I don't see any other live questions right now, talking about what the visa bulletin says, because this visa bulletin is hot, fresh off the press, and the things on the visa bulletin are sort of a bummer. So here's what we got. Retrogression in the employment-based second preference EB2 category for the rest of the world countries. Here, and they say, due to increased number use, it has become necessary to retrogress the EB2 final action date for the rest of the world countries. Bummer. The issuance total in this category is rapidly approaching the annual limit of fiscal year 2025, necessitating a slowdown of visa issuance rates. It's likely the annual limit will be reached sometime in August, if not sooner. And note that the EB2 annual, and this is normal, if they get to the annual limit, what they're going to immediately do is update the visa bulletin to say unavailable. They'll change the date to a U, and that means you won't be able to file any more cases based upon that. And again, it's really sort of interesting to see what they're saying here, because one thing I've noticed is they haven't very recently commented on the availability of visas at the bottom of the visa bulletin. But here's what they say about visa availability in the employment-based third preference. Visa demand and number use remain high in the EB3 and the EW visa categories, and issuance totals are approaching the annual limits for fiscal year 2025, saying the same thing. And there's also talk about EB5 here as well, but the bottom line is this. This doesn't really surprise me. We are over halfway through July, and meaning the fiscal year has has the month of August, month of September, half a month left here. If the government is doing their job right, I guess they should be getting towards the end of visa availability for the year. That's that. When their ideal version of doing this is, use the last visa on the last day, because even though for people, say, born in India or China who are very excited to have visas fall over to the next their category, their backlog category, the government can't really, the government can't just, wait half the fiscal year and move them all to those categories, because those people, people with cases from those rest of the world countries are going to have cases throughout the year, meaning you kind of have to wait until the last minute to shuffle those visas over to India, China, backlog countries, because you are sort of obliged under the law to give those visas, to the people from the rest of the world countries first. So it is darn near 6:30 p.m. I'm going to take this last question here, and then I'm going to wrap it up, because I have 1 minute left. Visa bulletin question. So Chandrakant Rajapurohit, hello, sir. Any reason why EB2 India are not moving forward since the last 3 months? And the answer is, there are so many visas available a year, and they use them up. And as I was saying earlier, the perfection is to use the visas up, use all the visas, and use them right up at the end of the year. As we get towards the end of the fiscal year, Sam and my's collective theory on the visa bulletin, on the dates for filing and the final actions, is that the dates for filing and the final action should come closer and closer and closer together as the year comes to an end. And we are, that's kind of what we're looking at now, I think. To be a silver lining, Chandrakant, the next fiscal year is not too far away, and the next big visa bulletin will be the October visa bulletin. And based upon dates and timing, if we already have the August right now, we are about 2 months away from that, which is exciting. I'm gonna, I can't resist. I'm gonna, these guys are getting questions in here, and I got a little bit of time for you. I'm going to answer a couple questions here. Here's one. My green card is approved, but the resident since date is wrong. It is off by a week. Should I get it corrected, and can I use a green card meanwhile? So that's a really difficult question because I would question the premise that they got it wrong. I don't have the details of your case, but it's reasonable for me to believe that, that the date they have on there is right. Being off by a week is, I mean, you tell me different facts, I might give you different answers. For example, if that's a marriage-based green card and they have your residence since date, a week before your green card interview, well, I think I might have a problem with that. But if it's, just a week later than you think it should be, it's the sort of thing where sometimes the online tracking of cases is not accurate. For example, I usually tell people that like the online USCIS tracking that might tell you when your case is initially approved is, 95% accurate. Meaning it could be possible that you got notification of your approval perhaps before it was truly approved. And I'm going to make this the last question that I answer. It's a great question, and it's something that we touched on in our YouTube, a few weeks ago. From Chaden, is Trump denaturalizing citizens? So one of the things we talked about, if you got the time, Chaden, go through our YouTube lives, and we covered this topic maybe a week or two ago, maybe about a week ago, I'm not sure. But basically, there is a policy out there that sort of indicates that they are going to turn more attention to denaturalizing U.S. citizens, but not without reason. That's sort of it right there. One of the things they're doing is basically looking to see whether people are accurate and true about things. So, and I'm going to answer this last question from Jedden here and be done. Will denaturalization be a concern if you have undisclosed marijuana use / purchase in the past? And I am truly going to wrap it up here, but it really depends upon when. Once you're a U.S. citizen, you are a U.S. citizen like anybody else, and that sort of thing is legal in a state. But if let's say if it was before you became a U.S. citizen, I'll give you a hypothetical. Let's say somehow the federal government gets access to a database of purchasers from a legalized marijuana store in state XYZ, and they find the name of somebody who naturalized in it. They could have a problem with that. And, it has been sort of alluded to that they might be doing more investigations, more searching, more trying to figure out if there's people who have been improperly naturalized. And that's something that's, out there in the world. But really, how much they act upon that really remains to be seen. I know this question here is just a hypothetical, but ultimately, during the last Donald Trump administration, there was a push to, find people who are wrongly deemed to be U.S. citizens and undo that. And the statistics on that weren't really super high. There was not that many cases I heard of where they actually followed through with it, because as mentioned again during that YouTube that my partner Sam and I did, to actually go through and take away somebody's citizenship is a bit of a complex task. It will typically involve a lawsuit in federal court. And one thing to sort of, emphasize about, the concept of denaturalization, it is a process. There are people out there who are fearful that, I'm going to wake up one day, there you go, one good snap, and I'm not going to be a U.S. citizen. And I think paranoia is healthy. I think it is scary and interesting times politically, but there is a legal process for denaturalizing somebody, and it doesn't happen overnight. So I am going to wrap things up. I will be back just by my lonesome next Wednesday, so just 2 days from now at 6:00 p.m. Eastern Time. And you know what it's going to be, folks? It's going to be a Q&A extravaganza. I'm going to sit down here and take any questions you can give me. I'm going to bat them right back at you with the best answers I can give, of course. Thanks, everybody. Have a lovely evening, and I will see you again on Wednesday.